Ladies and gentlemen, welcome. Thank you for coming. Please welcome Courtney Green and Melanie Perlman.
As you all know, terrorism is an increasingly dangerous threat, not just to Americans, but to all civil societies which value human life and support fundamental democratic principles. The Center for Empowered Living and Learning, the CEL, is a nonprofit, nonpartisan institution that exists to educate people about the realities of today's global terrorism threat and to empower them with the necessary tools, education, and awareness to help combat it.
The CEL is not only a dynamic interactive exhibit on global terrorism, it is also evolving into a center of counterterrorism education and preparedness training.
Tonight's debate is the first in a series of programs the CEL will host, bringing world-renowned experts on terrorism to Denver to foster a meaningful dialogue about the myriad of issues that stem from the reality of today's deadly tactic and its effects on our everyday lives. By bringing some of the most prominent thought leaders to Denver, the CEL will provide the community with the opportunity to expand their knowledge about this difficult subject so they can better understand what they can do to help combat terrorism.
The CEL's mission is to create a community that is educated, engaged, and empowered to help fight against terrorism. And to do this, we invite you to become part of the CEL community. As a member, you'll be receiving invitations to timely programs such as this one here tonight, information from our renowned subject matter experts, and other benefits. Tonight, we'd like to invite all of you to take the first critical step in this effort by filling out a membership card in which you're handed while you entered the Denver Art Museum. Together, we can play an integral role in the fight against terrorism. At this time, we'd like to invite Larry Meisel, the founder of the Center for Empowered Living and Learning.
It's a nice thing to be worn 3 times. It's a little shaky up here. I'd like to welcome our guests, my friends, members of the community. We're very honored that this is an opportunity to bring a very timely subject to Denver. We were co-sponsored this evening by the Anti-Defamation League, and I'd like to personally thank their executive director, Bruce Dabosky. Where are you, Bruce? As well as the University of Colorado Denver School of Public Affairs, who equally played an important role, and we would like to thank very much the University of Colorado Denver. Thank you. This subject matter, and I think of its relevance, I saw in the morning paper, and I'm sure the speakers will comment in the Denver Post, there was 2 articles. And it's interesting how money plays a role in the issue. Of course, that's kind of after the fact, but it's before the next move, which I guess deals with where they're going to move everyone or not. But we will hear more about that in a few minutes. I know that many of you here have really a strong belief and are very, very passionate about the rights of those that are involved with this issue. It's a very strong issue, and tonight we expect to have an opportunity, as they say, to have a nice civil discourse. Melanie, does that mean they're not supposed to yell at each other, right? Okay, I got that. And this is something that I think all of us, because of being here in Colorado And being in this country, we find that the issues are so relevant to today's times. I'd like to personally welcome our distinguished guest, Senator Gary Hart. Thank you, Gary. Charles Cully Stimson, thank you. And Gabor Rona, thank you for your attendance. I'd like to give a very brief introduction of a very good friend of ours, Senator Gary Hart. Short one, huh, Gary? I got 16 pages here. CV, bio, and articles. Most of us know that Gary is currently serving as a scholar in residence at the University of Colorado. He's a distinguished fellow at the New American Foundation. Since retiring from the United States Senate, Senator Hart has been extensively involved in international law and business. He was co-chairman of the U.S. Commission on National Security for the 21st Century. The commission performed the most comprehensive review of national security since 1947, predicted the terror attacks on America, and proposed a sweeping overhaul of the U.S. national security structures and policy for the post-Cold War period. He is also co-chairman. He co-chaired the Council on Foreign Relations Task Force on Homeland Security, which released its report, America Still Unprepared, Still in Danger. During his 12 years in the United States Senate representing Colorado, Senator Hart served on numerous committees, including the Armed Service and Intelligence Oversight. We're very, very honored to have a great friend of ours, Senator Gary Hart.
Larry, thank you very much. I'm honored to be invited to join you here this evening. And I'll return the favor for the kind remarks that Larry made. Larry and I have both been lifelong Republicans. It's kind of a personal joke. But I have had Larry's support in the past, and I can honestly say of all the many citizens of our community and families, I know of no family in the greater Denver community who has done more for this city and this state than the Meisel family, and the center is a continuation of their great citizen contribution to our community. I've also been instructed as the kind of maitre d' or major domo here this evening that we will, after our guests and I have had some chance to discuss the subject of the evening, we will take questions from you for them, and you will, there will be passed out or be available to you somehow index cards if you don't already have them. You are requested to write your questions on those. They will be collected, sent up here in about 30 or 40 minutes, and we'll go through as many of those as we can. Let me welcome our two visitors, neither of whom has spent a great deal of time here. You will tell by their very brief bios, and they are brief condensations, that they are uniquely qualified to conduct this discussion here this evening, and from rather diametrical points of view. First, Professor Gabor Rona, who is currently with Human Rights First. He is the International Legal Director of that organization and has been for the past 4 or 5 years, and advises Human Rights First on questions of international law and coordinates international human rights litigation for the organization. He has, before being at Human Rights First, been affiliated with the International Committee for the Red Cross. In that capacity, he focused on the application of international humanitarian and human rights law in the context of counterterrorism policies and practices. In addition, he represented the Red Cross, the International Red Cross, in connection with the establishment of the international and other criminal tribunals. He has taught and by the way, including the International Criminal Court. Professor Rona has taught international law having to do with human rights issues in both France and Switzerland. In addition, joining him will be Charles Stimson, who was Deputy Assistant Secretary of the Department of Defense before joining the Heritage Foundation, where he currently is located. Former Secretary Stimson is an expert in criminal law, military law, and detention policy, and combines all of those fields of expertise in what he will say here this evening. In his capacity as Deputy Assistant Defense Secretary for Detainee Affairs, he advised on detainee issues worldwide, including at Guantanamo, Iraq, and Afghanistan. In that capacity, he coordinated the Defense Department's detention policy and operations with the National Security Council, the Justice and State Departments, the military services, and the intelligence communities. He is a decorated military veteran, is currently Judge Advocate General Instructor at the Naval Justice School. Both these gentlemen have appeared widely on national and international media outlets, too numerous to mention, and I'm sure when you see them and hear them, you will feel familiar with them. Please welcome Professor Rona and Mr. Stimson.
You're right.
We will not rock the boat in our own security interest. According to his bio, you are welcome to call Mr. Stimson Cully, but given his background, you will do so at your own peril. Let's begin not with the history of warfare that goes well back, predates Homer 2,500 years ago. But let's begin in the mid-17th century with the Peace of Westphalia. And that was important 350 years ago because it is widely believed to be the date of the creation of the nation state. And the nation state, the governments of the world as we know them, pretty much, have existed in that capacity over those 3.5 centuries because of what some scholars have called the Grand Bargain. And the bargain was between the state, or the government, and the nation, or the people. And the bargain was the state said to the people, in exchange for your loyalty to our flag, whatever it was, and your willingness to serve in our army, we will protect you. And that bargain has held more or less over that period of time. And it is because of that bargain that we have the nation states we have today and the international agreements that have arisen over those 3 centuries. What this bargain also included was a monopoly on violence. And that's part of the reason that for 350 years, a relative political stability has prevailed. Because not only would the government or state protect the people or the nation, but in a more colloquial way of saying it, if any killing was going to be done, the government would do the killing. And part of the guarantee of protection for the citizens or the nation was external as well as internal. We will protect our borders from foreign invasion, and we will protect you from internal violence. We own the weapons, and only we can use them. That prevailed well into the 20th century when, of course, we had the big wars, World War I, World War II. And in the process of legitimizing, if you will, violence and conflict between and among nation states, rules of warfare arose. And those were codified not only by national law, but also by international convention, basically in what we know as the 4 Geneva Conventions, having to do with treatment of prisoners, repatriation of prisoners after the end of the conflict, how civilians should be treated. Those began in the mid-19th century and prevailed all the way into the mid-20th century in terms of the evolution of those conventions. We also, and other nations as well, our respective militaries developed their own codes of conduct, and we have field manuals for the Army and other units of our military as to how they are to conduct not only themselves with regard to civilians, but how they are to conduct themselves with regard to prisoners. Now, all was well and good if you believe in that kind of organized violence and restriction of violence, until the nature of conflict and the nature of warfare began to change. We won't go into the history of that, but basically what happened in the second half of the 20th century is the nation state lost its monopoly on violence. And the nation states of the world were no longer able to coerce non-state actors or stateless nations into playing by the rules. And nowhere was that more visible than on our shores, September the 11th, 2001. And that was, if you need an important date, and we don't anymore, but you can mark that down in a way, not as the end of the nation state, but certainly as the end of the nation state's monopoly on violence. Why is that significant for our conversation tonight? Simply because of this. As Mr. Stimson will verify, when we began to capture people in Afghanistan and round up people on our own shores, suspected of having to do with that attack, we didn't know what to call them. Because if they were our own citizens and violating our own laws, they were criminals and therefore subject to the criminal jurisdiction of the courts of the United States. If, however, they were enemy soldiers, then they fell to some degree under international law and required treatment under the Geneva Conventions that we were signatories to. And it was at that confluence that we began to hear words like enemy combatants, non-uniformed combatants, and various new phrases that weren't quite warrior, but they also weren't quite criminal. So that's the stage, and now I'll turn to the first question to Mr. Stimson. And let's get right to the heart of it. Do you or do you not believe in waterboarding Mr. Hannity?
Don't throw me such an easy one in the beginning. First off, I want to congratulate Mr. Mizell on this wonderful museum. If you haven't taken the tour, do it. It's terrific. And I will get to your answer. I want to thank you for hosting this, and it's a pleasure to be on the same stage with you and my friend Gabor. I think waterboarding is torture. I've always maintained that. The CIA has acknowledged that they waterboarded 3 of the high-value detainees. You can read those so-called torture memos, and some draw very fine lines and say, well, if you didn't have the specific intent to draw harm to the person, then you aren't technically guilty of torture. Look, anyone in the audience, anyone want to be waterboarded, raise your hand. Answer, nobody. I came to the department, as Gabor knows, late in the game. I came to the Defense Department in 2006. A lot of the damage had been done. By the CIA's own admission, they'd already waterboarded the 3 gentlemen and stopped by then in late 2003, I guess it was 2003 when they stopped. It's against our values. Did it produce intelligence? If you read the 9/11 Commission report, you'll see in the narrative, the factual narrative, 70 to 80% of it comes from the interrogations of Khalid Sheikh Mohammed, the mastermind of 9/11, and Abu Zubaydah. It's interesting that we've crafted a lot of our counterterrorism policies based on the 9/11 Commission report, yet at the same time we abhor, most of us do, for good reason, waterboarding. Yes, we do waterboard our own military, especially the SEALs, but we do that to toughen them and get them used to some of the tactics we know the enemy might use. Of course, we can't prepare them for being beheaded. So the short answer is it's wrong. It's always been wrong. We shouldn't do it. And that's a simple but straightforward answer.
But would you waterboard Mr. Hannity, who says it's not so bad?
I wouldn't waterboard my worst enemy.
Okay.
I wouldn't waterboard anybody. Now look, there is the question, and I'd be interested to see what Gabor has to say about this. There is the following question, and Alan Dershowitz talks quite eloquently about this, and he says, Alan Dershowitz is the famous Harvard Law School professor, and he says, no president, I guess he puts it in the positive, any president, any head of state would, if presented with the ticking time bomb or like scenario, not endanger thousands or tens of thousands or millions of people in his country if he knew or thought he knew or she knew that the person had the information to defuse the ticking time bomb scenario and order waterboarding. He's probably right.
Let's turn that question to Mr. Rona. Is there any circumstance under which you would approve torture?
Well, first of all, let me also express my gratitude for the invitation to be here. It really is a pleasure and an honor to have been invited to be on the same stage with both of you gentlemen, and to have this opportunity to talk to an audience that is beyond the borders of either New York City or Washington, D.C.
Amen.
About this is real America.
About
Yep.
these subjects. The question of whether or not torture is ever permissible. Now, you're going to hate me for this because I'm going to draw some fine lawyerly lines. Torture is never permissible. However, there may be circumstances in which it could be excusable.
Do you want to switch places here? You can sit on the right, I can sit on the left.
However, the idea that the ticking time bomb scenario should dictate our policy on detainee treatment is woefully misbegotten. In the experience of the United States in detention policy and interrogation of detainees post 9/11, I think what we have seen is that tremendous abuses were visited on detainees, some of whom no doubt did terrible things. Others were proven to have been simply in the wrong place at the wrong time and delivered into the hands of American authorities by virtue of other people having been offered bounties, tremendous amounts of money to rat on their neighbor, for example. So you have a mix of people that have been in detention. And U.S. policy, it seems, was to try to get actionable intelligence for the purpose of thwarting the next terrorist attack out of these individuals. Now, my organization, Human Rights First, has spent a lot of time talking to experienced interrogators. And what we learn to an individual, what the experienced interrogators tell us, is that you do not gain actionable intelligence by abusing people. You gain actionable intelligence by gaining their trust. And in fact, I think the experience in a couple of particular instances was when the FBI was interrogating certain individuals, and using techniques that relied on gaining trust, gaining confidence, establishing rapport. We were getting some useful information from some of these detainees. When the CIA stepped in, and on the basis of instructions and permissions from on high to use so-called enhanced interrogation techniques, the information flow tended to stop. And when the information flow didn't actually stop, what resulted was information that we couldn't trust, because as experienced interrogators know, people will say anything to make the abuse stop. Now, the Israelis, for example, can document situations in which a person was detained, the Israeli authorities had good information that the individual knew of an imminent attack, and they wanted to be able to get information from that individual quickly. And they did so through the use of means that I, and I think probably Cully, would call, at the very least, cruel, inhuman, and degrading treatment, if not torture. There are situations in which, if torture, although it is illegal, can be justified and excused, but for the ticking time bomb scenario to generate an entire detention policy, to be the common denominator for establishing our rules, is not only against our law and against our values, but is also extremely counterproductive. So as a matter of practice and policy, I think the correct answer is that torture should always be forbidden.
Mr. Simpson, in the public policy arena in which you were operating, to your knowledge, did the following discussion occur, or should it have? We can waterboard or torture, use whatever extreme methods, euphemism there was, on Sheikh Mohammed, and possibly, indeed, get some information. That's important. But we know for sure, if this treatment gets out and is publicized throughout the Arab world, it will lead to the recruitment of an awful lot of new young terrorists. In your knowledge, did that debate ever occur?
It's a good question, and it ties in clearly to what Gabor said, and it requires a little bit of history setting here. How many detainees has the U.S. picked up since 9/11? Anyone want to hesitate a guess? Over 50,000 or below 50,000? Above. About 100,000 people in Iraq and Afghanistan. Now, many of these are recaptures and recaptures and recaptures. You let them go, they go back and do stuff, we recapture them. But the detainees at Guantanamo mainly, not always, but mainly came out of the conflict in Afghanistan, and about 780 detainees came to Guantanamo in January 2002, when, by the way, I was involuntarily recalled back into the military to be a defense attorney for potentially detainees. Obviously, the president didn't give detainees military lawyers back in 2002, so I defended common variety sailors and Marines who were accused of crimes. To my knowledge, 2 detainees at Guantanamo, Slahi and Katani, were subjected to enhanced interrogation techniques one approved by Secretary Rumsfeld, one approved by General Myers, and it was for a short period of time, I think 2 or 3 weeks. It must have seemed like a long period of time to them, but I'm saying in chronological days it was a short period of time. Contrast that with the CIA's program. General Hayden, the former CIA director, has said that the CIA has had just under 100 detainees in their entire length of their program. Those were the detainees who those torture memos applied to. Military interrogators, FBI agents, as Gabor said, JAGs, were, to say the least, put back, concerned, to say the least, about abuses that occurred to any detainee. We're all trained to the Geneva Conventions in the military. You know that, having served on the SASC and the SISI, Senate Select Committee on Intelligence. I'm not calling him a sissy. And that's all we know. So when the first JAG, Major Ian Brazier in the United States Marine Corps, was in Afghanistan, when we rounded up the first guys and brought them to Bagram on December 18th, 2001, Ian had no guidance as to what rules applied, except he defaulted back to the Geneva Conventions and treated them consistent with the Third Geneva Conventions for prisoners of war. And so I would suggest that by the time I got to the department in 2006, and this is, I think, directly answering your question, it was very clear, because Abu Ghraib had happened 2 years before, that mistakes and abuses and indeed criminal acts have, to detainees, have worldwide reverberations. Not only did it damage and sully the image of the United States of America, but it put our own soldiers, sailors, airmen, and Marines in harm's way, and some were killed because of it. And so we were very set on getting the Army Field Manual on Interrogations right. And I argued against a classified annex of techniques because I thought that would send the wrong message to the world. And so what we ultimately ended up with is 19 techniques for the world to see, the same techniques that essentially most police officers use in this state and every other state. But the CIA still had their own programs. So no, we never talked about waterboarding because the DOD never did waterboarding. But we were aware that there was other program over there, and I was never invited to go to the CIA to talk to them about that. I think they probably knew my opinion as a JAG. But the vast majority of detainees were DOD detainees, and you had 19, 20, 23-year-old interrogators who needed a very clear Army Field Manual on what they could and couldn't do, and no gray. And so that's where we have been since 2006. And I think that's why President Obama said, okay, CIA, you're stuck with the Army Field Manual for now until we study this ourselves. And I think that's the right policy, and they're studying that.
May I add two quick observations to that very quickly? I think the most frequent argument for why terrorism is bad for us is the concept that it creates a recruitment tool. There's another point, and this is something that has been told to me by military personnel. When you're confronting an enemy, and that enemy is considering whether or not to surrender, he's going to have a very different equation in mind if he thinks that upon detention he's going to be subject to torture than if he thinks that upon detention he's going to be treated humanely. Second observation, we've spoken to instructors of interrogation at West Point. They tell us that their biggest problem is Jack Bauer. Their biggest problem is Jack Bauer because the young kids that come into their classrooms watch 24. They've seen this on television. It works, and so they come in with a predisposition toward using the kinds of techniques that are familiar to them, and they have to be diseducated before they can be educated.
Very frightening.
Good point.
As a political matter, just a quick answer if you can, not knowing you were on the scene at the time, when the decision was made to designate this new breed of cat legally as an unlawful combatant, was that a conscious, purposeful effort to avoid both, on the one hand, the system of international law and conventions and the criminal justice system, or was it just because they didn't know what to call these people?
I think more the latter than any of the former options. Clearly, under the Geneva Conventions, if you fight for a country that's been a high contracting party to the Geneva Conventions, and you follow the law of armed conflict, and you carry your arms openly, and you follow the chain of command, et cetera, all requisite things you need to have to enjoy prisoner of war status if captured, you're a prisoner of war if captured. That same person, though, if they strip themselves of their rank, hide, clandestinely attempt to kill civilians, they would be an unlawful combatant. They would lose combatant immunity. Why is that important? Because lawful POWs cannot be interrogated. Unlawful combatants can be interrogated if they choose to speak with you. They can also be prosecuted for war crimes. So I think it was more the latter than the former.
Well, then,
I think Gabor probably disagrees.
from the point of view of international law, if I'm correct about, and not just my opinion, it's the opinion of a lot of people, the evolution of conflict and warfare and the rise of, dramatic rise of irregular or unconventional warfare, do we need a fifth Geneva Convention for the treatment of non-state actors who can't be legal or illegal?
No, we don't. And I'm really glad that you gave the little background talk that you did about the history of the monopoly on the use of force and how that has really withered away in recent years. But the fact is that the Geneva Conventions contemplate both kinds of armed conflict. The kind of armed conflict in which the state exercises use of force in its monopoly role, and that, according to the terminology of international law, is what is called international armed conflict. Now, that doesn't mean any armed conflict that takes place beyond the borders of a single state. It has a more specific meaning, and that is armed conflict between two or more high contracting parties to the Geneva Conventions, namely states, intergovernmental armed conflict. But the Geneva Conventions also have provisions for armed conflict that does not involve fighting between two sovereigns, non-international armed conflict. And while it's absolutely true, as Cully says, that if you're a fighter for a state, a member of the armed forces, you have this privilege of belligerency. You're not a criminal for involvement in hostilities, and you're entitled to POW status. But if you're a civilian who participates in hostilities, you don't have that privilege. To do so is criminal under domestic law. But that also applies equally in international and non-international armed conflict. In addition, there's a provision of all of the Geneva Conventions, it's Article 3, and it's common to all 4 of the conventions, which provides a floor of rights and responsibilities in such armed conflicts, civil wars, rebel groups. It provides for the basic prohibitions of inhumane treatment of detainees. It requires fair trials when detainees are tried. And there is also an additional protocol to the Geneva Conventions, which the United States is not yet a party to, but I think will probably become party to sooner or later, that deals exclusively with those kinds of armed conflicts in which it is not states exercising a monopoly on use of force, but involves rebel groups, civil wars, etc. So I think the answer is we do not need a new Geneva Convention.
Mr. Simpson,
I agree with that.
let's get really brutal with Professor Rona, if you don't mind.
Oh.
You see, I mean, in the world in which we live, we've got drug cartels, which are virtual private armies in Mexico, south of our border.
Yep.
We have religious fundamentalists threatening to overthrow Pakistan that has nuclear weapons. We have emerging Russian mafias, weapons of mass destruction that may get loose from Russian arsenals, and so on. Is Professor Rona and people like him stuck in a century that isn't relate to reality anymore? Are we living in a post-civilized world?
Jack Reed, the former defense secretary in England, said back in 2005, we're fighting a 21st century war with 20th century rules.
That was a better way to ask my question. Thank
Well, I
you.
wasn't trying to up you. I'm just trying to sort of put things in historical context.
Why didn't I think of that?
And of course, when you were in office, you remember what
Many years ago.
what Gabor was alluding to was Additional Protocol 1. And when Ronald Reagan was the president, and the New York Times and the Washington Post both editorialized against becoming a party to Additional Protocol 1 for the specific reason that they were concerned that non-state actors would attain the legal status of prisoner of war if captured. Now, a lot has changed. Maybe the New York Times and Washington Post have changed, I don't know. But in terms of policy, when I was in office, I had the privilege of being in the room when we finally made the right decision to wholesale pick up verbatim Common Article 3 to the Geneva Conventions and adopt it as our written policy and put it in the overarching DoD directive. And we added Article 75 of Additional Protocol 1, which are adequate food, health care, access to medical, all the sort of treatment provisions of that into the same directive. So that's important. I can tell you that I have immense respect not only for Gabor's current employer, but his previous employer, the International Committee of the Red Cross. They helped me do my job better. They alerted us to shenanigans in Abu Ghraib before they broke. They alerted us to a lot of things that if we had listened and we had a single point of entry in the Department of Defense, we could have avoided it. I saw them as a canary in the coal mine, and I enjoyed a good, close and confidential working relationship with them. Behind the scenes, and I think Gabor may be willing to discuss this, there has been a lot of work coming to grips with this very issue of can we come to a universal understanding of who a terrorist is, which is a tough thing to define. Terrorism is easy to define, terrorist. And then how they fit neatly within, or not neatly fit within the current Geneva Conventions. I think they do. I think that perhaps there may need to be some tweaking of Additional Protocol 1 to take this into consideration. But I think the Geneva Conventions have served us well. I think that they will continue to serve us well. And I think it's very clear under the law of armed conflict, which is the paradigm that the Obama administration and the Bush administration is using, that you can detain some number of these folks without being forced to charge them.
Well, before we get the questions from the audience, this has all been too lovey-dovey.
I'm a nice guy. I don't
for
know how
those
to,
of us who came
beat up.
here for a fist fight, but
Go ahead, Gabor. Take your best shot, and then I'll...
let me try one more time to
all right.
start a fight here.
All right.
Would you or would you not have the United States subject itself to the jurisdiction of an international court of criminal justice?
No.
Would you?
Yes.
There you go,
You
folks.
happy?
We're done. Good.
No. There are some cards out there with much more penetrating questions than I could come up with. If I do, thank you very much. That's enough. Too late. Okay, let's start with this one because there are some others coming. Where no addressee of the question is listed, it'll be a jump ball for both of you. What interrogation methods, we'll start with Mr. Stimson, what interrogation methods should the CIA and other intelligence agencies use now that the CIA memos have been released by the Obama administration?
Well, they are required under the executive order to follow only those 19 techniques that currently exist in the Army Field Manual. I can tell you as a former local, state, and federal prosecutor, though, that when we were in the room debating those 19 techniques with a small group of us, I had a whole list of other techniques that police officers use in interrogation booths here in the United States that are perfectly lawful, like lying, that should be included as a technique. We didn't include it. The Army was uncomfortable with it. Can you imagine the CIA not being able to lie? Isn't that why we pay them? I think, in all seriousness, they should have additional techniques that are lawful, but we shouldn't know what they are. We shouldn't tip the enemy off.
I was a criminal defense lawyer for about 15 years before I got into the human rights realm. And once again, I hate to disappoint you, Senator. I agree that there are other techniques that the CIA should be able to use, like lying to a detainee in order to get information. However, where I disagree with Cully, I think, is that even within the Army Field Manual, there are techniques permitted that amount to at least cruel, inhuman, and degrading treatment, which is prohibited by the Geneva Convention.
For example?
For example, sleep deprivation and isolation. Again, having talked to experienced interrogators, I have learned, we have learned, and I don't know if any folks here, I'm sure none of you have been waterboarded, but I'm sure you've suffered some degree of sleep deprivation. The Nazis were pros at sleep deprivation as an interrogation technique. Sleep deprivation will kill you, taken to its natural extremes. And that is one technique that I think should be absolutely prohibited, even though it is still within the Army Field Manual. Another is, as I mentioned, prolonged isolation. It will make a person crazy. This is not good for interrogation purposes as well as for humanity purposes.
I was waterboarded by the press one time, but that was a long time ago.
So was I.
Not like I was.
Right.
This
I
is
feel
for
your
both
pain.
of
Not
you.
going to touch that.
It's, you're all too young to
We
remember.
can arrange
so,
it for you, Gabor.
I remember.
For both of you, what do you think about calls for a U.S. Truth Commission? Lay it all on the table.
Yeah, it's interesting. When I was in office, Senator Levin was gearing up for a whole series of hearings, hired staff, was always sending requests for information from my office. No doubt he was doing that from the CIA, from the DoD General Counsel, from the Department of Justice. I'm not sure that there is a need for a Truth Commission, since the Senate Select Committee on Intelligence is conducting, I think, a very pinpoint, laser-focused inquiry, and I think that that committee has the ability to expand its charter to get what it needs behind closed doors. Look, some things are classified for a reason. Other things are overclassified, and we shouldn't be classifying things. You know, we've gotten to this business of overclassifying two-minute stuff. I don't see the need for it, but that's more of a political judgment than a legal judgment.
I disagree with that profoundly. We live in a democracy. The ultimate authority and the ultimate responsibility for what our government does is with the citizenry. And if the citizenry are not informed, if the citizenry are not trusted with the information that is necessary to determine what is being done in their name, potentially crimes, then we have lost the essence of our democracy. For these reasons, I think it's absolutely essential that a process takes place on which public light can shine in order to determine what was done, why it was done, who ordered it to be done, and what the consequences were.
Mr. Stimson, I should know the answer to this, and I don't. I was a veteran, again, much too long ago for any of you to remember, but of a committee in the Congress called the Church Committee that was the first congressional investigation of the intelligence community, principally the CIA. And I don't know why the CIA, and I'm a supporter of the CIA's, and a defender, but I don't know why they're doing the torture. That's not their job. I mean, if there are going to be torturers in our government, why not the Defense Department or the FBI? The CIA's intelligence gathering and analysis. Who put these guys in charge of torture?
I don't know. I can tell you that Secretary Rumsfeld did not want the detainee mission at all. He did not want to be the jailer. He thought the Department of Justice should be the jailer, but it devolved to him, and I don't know, and this I think serves Gabor's last response probably quite well. I don't know how the CIA program got started. I don't know who made the call and said, okay, you guys are going to do it. I will note that David Addington, the chief of staff and top lawyer for Vice President Cheney, was a CIA top lawyer in years past. Maybe that had something to do with it. I don't know.
It's not the agency's job. Professor Rono, what are your thoughts about the Senate's failure to finance the closure of Guantanamo? I know what mine are, but what are yours?
Well, I don't think we've seen the last word on this issue by any means. I think it's a real tragic abdication of duty of Congress to allow the president to do what he needs to do in order to effect the closure of the detention facility at Guantanamo. The idea that we cannot close Guantanamo because we don't want terrorists running around released into our cities is frankly absurd. There are over 120 cases in our federal courts of prosecuting international terrorism, both before and since 9/11. And our federal courts have dealt exquisitely with the challenges of prosecuting international terrorism cases. The idea that if we shift Guantanamo detainees, even those who we want to put on trial, onto the shores of the United States and possibly into the operation of our normal federal criminal justice system, that we will then have terrorists running around on our streets, I frankly find absurd. And the importance of closing Guantanamo as a detention facility is so great. The need to resolve this problem of individuals having been detained, some now for more than 7 years, without having been charged with a crime, many of whom courts have found to have been erroneously detained. This has got to stop, not only for the sake of the United States coming back to the values that are important to it, but also for reestablishing the ability of the U.S. to rely on its allies for cooperation in counterterrorism, to rely on the appreciation of the rest of the world for the United States' willingness and ability to uphold fundamental human rights. These are such important interests, such important values, and the counter-argument of the idea of somehow terrorists roaming around on the streets if Guantanamo is closed, I find is just irresponsible.
Is it possible for the United States in the 21st century to take the position that there are people, one, who cannot be put on trial, and two, who can never be released, and therefore, without any kind of legal process, are going to be in jail for the rest of their lives?
I hope not. I
Well,
hope it's not possible.
It is being said that that's the dilemma we're in.
Yeah,
How many of those people, I don't know.
Yeah, the Obama administration, in their court filings and their public statements and their nominees to head the Department of Justice, the CIA, and even Secretary Clinton, have all maintained that you can hold some number of Guantanamo detainees and others without charging them. I don't think anyone pressed them during their confirmation hearings or even during press conferences. Does that mean forever? But it is not true to say that you can't do it without some sort of procedural legal protections, because that must happen. And as you all know, last summer the Supreme Court issued their opinion in the Boumediene case, which said that detainees at Guantanamo enjoy the constitutional right of habeas to challenge their detention in federal district court. That's right and that's good, and I think that was predictable. Now the question is whether some small number of detainees in Bagram in Afghanistan can petition to challenge their detention in federal district court. But I think that the Obama administration is taking its time. It needs to take its time. These are complicated issues. I think that I know that the Geneva Conventions envisions a periodic review for basis of detention. I think the Obama administration is clearly going to enshrine that in any detention policy going forward, whether it's every 6 months, every year, with a federal judge, et cetera. That remains to be seen. But no due process, no process, indefinitely detained in a vacuum, hopefully will never happen again.
In case you haven't noticed, the three of us are united by one fact, and that is we're all lawyers and suffer under that burden. I have to say, without being asked, I think in my lifetime, the worst action taken by the United States Senate was the passage of, I don't know how it's designated, the Second Patriot Act or whatever it was, which gave the President of the United States virtual unlimited ability to suspend habeas corpus. For those of you who are non-lawyers or haven't studied legal history, there is no single proposition more central to what we call the rule of law than the writ of habeas corpus, meaning the king cannot put you in jail without telling you why. Now, if there's something more fundamental in law, and that of course comes from Magna Carta, it's what began the whole process of the legal democracy that long ago. And the Senate of the United States surrendered that central right to the president at his whim. I don't care, Democrat, Republican, George Bush, Barack Obama, or anywhere else. It was despicable. I won't go into who voted for and against it, but I'd like to, and if you want to meet me over there, I'll tell you who in this state voted for it. Okay.
That narrows the list, obviously.
This is also a question I guess I've got to answer, we can all answer. Given the breakdown of the power, my formulation, the breakdown of the power of the nation state and its monopoly on violence, and the rise of the strength of corporations and private interests within battlegrounds and wars, is all violence terrorism? Well, the question doesn't quite lead to the formulation doesn't. This is an interesting question, folks. I'll let our panelists discuss the privatization of warfare, which I didn't mention, but it's a very interesting, the use of contractors to, in some cases, carry out the torture. Of course, all violence isn't terrorism. And as many people pointed out over the last 8 years, to declare war on terrorism, which is a method, would be the World War II equivalent of declaring war on blitzkrieg. Terrorism is a method used by various organizations to achieve an objective. You don't declare war on the method, declare war on the people carrying that out. I mentioned drug cartels in Mexico. I suppose they're terrorists. They certainly use terrorist tactics. I don't know that those cartels are on any terrorist watch list here in the United States. Certainly, Al-Qaeda operating in Pakistan is, I think we'd all agree, is terrorists. But are the Russian mafias terrorists? In some cases, yes. Some cases, no. If they get a hold of a nuclear weapon, they sure are terrorists in my book. But not all violence is terrorism. That's part of the vagueness of declaring war on terrorism.
And I think one of the things that, even though there is no internationally accepted definition of terrorism that most everybody agrees on, is that the concept of terrorism should be limited to attacks on civilians and not the kind of use of force that you spoke of earlier used to be subject to the state's monopoly, namely armed forces fighting against each other. Those are in fact privileged forms of violence under international law.
And I think you would agree, if I could jump in, Senator,
Sure.
That, for instance, somebody like Timothy McVeigh, he attacked innocent civilians and children, bombing the Murrah building. It's a terrorist tactic, but he shouldn't be held without charge.
Right.
I mean, so it is a question of scale, isn't it? I mean, clearly that's what you're pointing to. If so-and-so gets a nuclear weapon, it's much different than Billy Bob going down the street with a stick of dynamite.
What about the contractors? I mean, I'm not comfortable with Blackwater or anybody else being given those privileges that the uniformed military has. Are there duties under the Constitution that cannot be contracted out and should not be?
I think there are. I think contractors need to be in a supporting element, logistics, security services, that sort of things. That doesn't mean that they are defenseless. And I mean, this is a 3-hour discussion we could have, but I think in terms of using them as an arm of the state in offensive operations, it offends my understanding of what the military is for in the first place, and I think the military is the primary vehicle through which we should project forward power, and especially kinetic power.
And armed forces are subject to a very tightly controlled chain of command, and they have responsibility and accountability in ways that protect not only the military mission, but the whole objects of foreign policy that involves the use of force. With contractors, you don't have that same systemic method of accountability. And so for contractors to be relegated the use of force that is traditionally the province of government is very dangerous for the entire military mission and for foreign policy.
And there's no better example than the MIJA, the Military Extraterritorial Jurisdiction Act. It came into being because of concerns that some contractors were not subject to the laws of the United States especially, but even the domestic laws. And so, this jurisdictional nexus, this hook, just sort of arose late in 2005, I think, 2004 or 5.
To your knowledge, have JAGs or Judge Advocate Generals of the various services who have been assigned or accepted assignment to defend detainees been penalized in their careers?
It's a good question. Some of whom are my former students from the Navy Justice School, and Charlie Swift, who Gabor and I know quite well, was a close and personal friend of mine. When I was recalled to active duty after 9/11, I served as a senior defense counsel with Charlie. I think the perception is they have been penalized. I hope that's not true. I'll give you my answer with respect to Charlie. When I met Charlie in early 2002, he was a lieutenant commander, which is like a major in the Army. He'd already been passed over for promotion to commander. He was planning on getting out. He'd served in the Naval Academy. We had a great time together. He's a good defense lawyer. We defended several cases together. And then commissions came up after I left. And then he raised his hand willingly and did a damn good job in that case. Obviously, he took the case the whole way to the Supreme Court, and now Hamdan's a free man in his home country. The storyline was that Charlie was punished because he took the case to the Supreme Court and he challenged the Defense Secretary of the United States government. The reality is Charlie had already been passed over. But I think there is a perception, and maybe it's true, that some have been penalized. I hope that's not true. These are my colleagues. I'm a military judge now. I've left the Justice School. I would be very disappointed and editorialize against that if that happened. I think that would be very wrong.
Here's one that I will handle. What empirical evidence exists to support the assertion, mine, that detainee abuse encourages recruitment of terrorists? Lots. Was
General Petraeus. He has said that numerous
Yeah,
times.
there you go. That's even better. Was Guantanamo established, I think, as a detainee center merely to avoid the U.S. Constitution and international law?
Partially. You have to understand that when the Bush administration and our country found themselves under attack in 2001, the law of the land, the Supreme Court precedent that was standing there all by itself was Johnson versus Eisentrager, which essentially was a 1950s case where post-World War II German prisoners were tried in Germany, and they petitioned for relief in the federal courts, and the Supreme Court said, no, you're a person with no ties to the United States, you didn't commit your acts in the United States, you're not a U.S. citizen, and therefore you have no access to the courts. And so the Bush administration relied on that, and I think that's probably why the Senate jumped up and down and said, hey, Gitmo, no habeas, great. But you have to understand that...
Well, by the way, the Senate vote was not just no habeas at Guantanamo. It was, Mr. President, you can suspend habeas corpus for anybody you want to for as long as you want to, full stop.
The base of Guantanamo, U.S. Naval Station Gitmo, was founded in 1903. It has had a lot of mission sets over the years, and it will have more mission sets after the detention mission leaves. But it was, among the various choices, the closest choice to mainland United States. It also was the indefinite detention facility that President Clinton used in the 90s for the Haitian and other refugees who were flooding the Caribbean to get the heck out of their countries. And so those detainees had challenged their detention in federal court, and they got the Heisman. Nope, no joy here. Look, I think, and I know, that the Obama administration is benefiting from the various mistakes the Bush administration made. One of the primary mistakes the Bush administration made early on is not going to Congress and consulting with them early on to say, hey, by the way, the generals in Afghanistan who are in charge of operations want these guys out of here. This is a new type of war where intelligence is critical. We're thinking about these 5 places to detain them. Can we get some buy-in from you guys? Can we talk about it and then get some congressional authorization for that? And I guarantee you, President Bush, Mush, or Dush, in 2001, in October, would have gotten congressional authorization for the establishment of a detention place, wherever it is, and it would have had the seal of congressional approval, and there would have been more buy-in by the country, and the president should have come out and very gracefully and eloquently, to the best he could, have spoken about why we did it in the first place with some congressional leaders right beside him. But we didn't do it, it was a mistake, and we've paid the price for it.
Besides which, if they broke out, it was Castro's problem.
And there's a lot of sharks in Guantanamo Bay. There really are.
I disagree with the idea that Guantanamo was chosen because it was close. And I think, Cully, you said earlier, because Senator, you asked this question earlier about, why was Guantanamo chosen? Was there some nefarious reason? There was definitely a nefarious reason. There is documentation of the purpose behind choosing Guantanamo was to find a place that was indeed a legal black hole, to find a place that, in the view of the administration, would be beyond the purview of judicial review. They turned out to be wrong on that one, thankfully. But it was not only the question of what was the purpose of Guantanamo, there's also the question of what was the purpose of the entire structure that the Bush administration created, particularly in a memorandum of the President of February 7, 2002, that excluded all of its detainees from the operation of the Geneva Conventions. So it was not only the establishment of Guantanamo, the place, it was the establishment of a whole extrajudicial and extra-legal framework of detention by which the United States and the administration tried to create a situation in which detainees could be made subject to abuse, could be held indefinitely, could be simply thrown away and not see the light of day of any either judicial review, public review, or for that matter, even visits from the International Committee of the Red Cross, which is an essential aspect of the application of the laws of war.
Thank you. Two final quick questions, and I think you can answer this very quickly. How relevant is the Geneva Convention or the Geneva Conventions if we and only a few other countries are following them? Most aren't.
I disagree with the premise entirely. First of all, the Geneva Conventions are the most widely ratified international treaties in the world. All of the problems that we've been talking about today, by the way, are not about countries violating the Geneva Conventions. It comes back to the point that you started us on, Senator, about the loss of the monopoly on the use of force. We're talking about rebel groups. We're talking about terrorist organizations. We're not talking so much about state practice and policy. The United States, during the years of the Bush administration, took an unfortunate detour. But by and large, the countries of the world not only are parties to, all are parties to the Geneva Conventions. They train to the Geneva Conventions, their military are versed in the Geneva Conventions, and there is by and large respect for the provisions of the Geneva Conventions.
Here's a generic question we'll end on. Had to happen. Should Dick Cheney be indicted by the International Criminal Court?
No. We cannot criminalize policy differences in this or any administration. If anyone has committed a crime, that should be dealt with domestically. We can't outsource our criminal justice model.
Well, there's a technical answer, which is that he can't be, because the United States is not a party to the International Criminal Court.
Should.
Okay.
Should.
And even if the United States became a party today, then the court would not have retroactive jurisdiction. However, I think anybody who promulgated and was responsible for the creation of interrogation techniques that violate international law, violate our obligations under the Geneva Conventions, violate our obligations under the International Convention Against Torture, should be prosecuted.
60-second final statement.
This type of meeting should happen all over the United States. Our national security is something that we all should be concerned about. Intelligent discussion, even with colleagues who we may differ certainly on the margins, should continue. This new administration has the opportunity, I think, to reset our counterterrorism and national security strategy with respect to this enemy who wants to see us all dead. And it should include military detention, properly calibrated with proper legal protections. It should include other common sense aspects that the Bush administration used and reject those that didn't work empirically. But I would urge all of you not to get all of your news from one news source. Stretch your boundaries. Read what you consider to be the opponent's positions, especially the thoughtful ones. Too much of this has been politicized for too long. Too many people are working hard behind the scenes to keep us safe. They're disgusted by the acidic nature of the political discourse. We need intelligent discourse, we need intelligent counterterrorism policies, and that, I think, will help us cleave to, continue to adhere to the rule of law, and help us humbly but forthrightly remain the best country in the world.
Professor Rona.
I'm really glad to hear you say that, Cully, because I too have been extremely dispirited by the quality of some of the discourse. It just does not touch upon the important issues in the way that I think the American public deserves to be and needs to be informed. I think the essence of how we go forward in constructing sound counterterrorism policy stems from the admonition that if those who do remember history are still forever condemned to repeat the lessons of it is true. It was Ben Franklin who allegedly said, those who would sacrifice liberty for a little bit of security deserve neither. And I would paraphrase that, those who would sacrifice liberty for a little bit of security will get neither. I think the important point for us going forward in considering each and every question about counterterrorism and counterterrorism policy is to absorb the fact that civil liberties and security are not diametrically opposed. They are complementary. The way that we will find ourselves best protected includes adhering to the values, the laws, the rules that created the nation that the United States is today. Its democratic values, its concept of fair treatment, and its essential adherence to the idea of the Golden Rule. We should not do unto others that which we would not want done to our own soldiers. If we keep those precepts in mind, then I think we will be able to shift gears into a much more effective counterterrorism policy than what we'd seen in the past 8 years.
The greatest protection of the freedom and security of the American people is our Constitution, and the greatest appeal we have to the people of the world are the principles contained in that Constitution. To the degree we live up to those constitutional beliefs and principles, we will be a great nation. To the degree we abandon them, we will lose both our freedom and our security. Thanks to Larry Meisel and the Meisel family, those who are running the cell, most of all to all of you for being here.